Yeah, I think when I first started doing treating doctors, I was so nervous about making sure that I got everything that I needed to get that I would go through every single record of every single visit with the doctor. And that's, I mean, the jury doesn't need it and you don't need it to support your doctor's opinions,
Yep.
really.
And hopefully you have a doctor that doesn't need it too. That's another issue we have sometimes with treating doctors that they want to read their entire record to you. So it takes a lot of work. It takes a lot more work to do a 30-minute treating doctor deposition or direct examination trial than it does to do a 3 hour one.
And just like with every expert witness, your doctor has to meet whatever the Daubert type requirements are in your state. So when you're creating your outline, you want to be thinking of your doctor as an actual expert, not just a witness in the case. But what do they have to show their methodology, their qualifications, all of those things without overdoing it? Because remember, you're doing this for the jury. You're also doing it to keep your verdict on appeal, but you're really doing this for the jury. And if they've fallen asleep by the time your doctor gets through his qualifications about where he went to from high school forward, then you're doing a disservice to your case.
And I do want to mention before we get to the actual direct exam, because this is something that's fairly new, but I see the defense bringing it up and I see some disturbing case law on it. So there is a growing line of cases that says that while a treating doctor can testify as to what they saw and did, if you want a doctor to testify about causation, that an event caused the condition, or if you want a doctor to testify about anyone else's medical bills besides the doctor's own medical bills, that you must not only designate the doctor as an expert, but in cases in jurisdictions that require reports like federal court, uh, and there's even one of the districts in New Mexico State Court I heard is doing this too. You must provide an expert report from that doctor, these courts are saying that the medical records aren't good enough, but you need to have an expert report where they explain how they came to their conclusion on causation, what their reasonable basis was, which is hopefully a differential diagnosis, and we can go into that in a little bit. But I just want to warn everybody because I almost got burned on this, and we've been doing this, and we're having to fight with the doctor sometimes because they're like, I've been doing this for 40 years, and I've never had to write a report. And I said, well, I've been doing this for 30 years, and until 2 years ago, I never had to get a report either. But if we want to get to trial and not have our case thrown out, a lot of jurisdictions, especially federal court, are requiring us to do like a full, they're treating us hybrid experts. So to the extent that they're treating, then they're just, their medical records are good enough. You don't need to get a report. But if you want them to say, did the crash approximately cause the injury, then you're needing to get a report from them. Or if you're wanting them to say, were these other medical bills reasonable in their price? Was this other medical treatment that other people did necessary? You're needing to get a report from them explaining their methodology and qualifications.
Right. And I mean, generally, if you're deposing a doctor, that's why you're deposing them, right? To get that
Yes.
causation opinion. I mean, there's not usually another reason to depose them because the medical stuff, I'm going to tell you, is pretty boring to jurors. So if you don't need it in your jurisdiction for some reason, or you don't need that particular doctor, then you should always ask yourself, do I need this witness? And are they helping me move the ball forward?